Good evening, ladies and gentlemen. It is a privilege and a pleasure to be with you all this evening with two eminent President's Council to discuss issues and recent developments in arbitration in Sri Lanka. Most of you have taken part in the Victor's Moot, and throughout the days leading up to the Moot and during the Moot, I am sure that all of you had an entirely educational and rewarding experience. And therefore, it is in this backdrop do we hope that this panel discussion would be the cherry on top of that experience, that cake. So introducing the panelists for today, let me first introduce to you Mr. Chandaka Jayasundara, President's Counsel. Mr. Jayasundara has specialized in commercial law with special emphasis on maritime law, international trade law, company law, intellectual property law, and arbitration, and counts over 30 years of active practice. He holds a LLM in international trade law from the University of Colombo. He has an experience in international and local arbitrations as counsel as well as arbitrator. He is also a visiting lecturer for the Masters of Law program at the Faculty of Law in University of Colombo on arbitration law. And also he has experience as a visiting lecturer on international trade law, admiralty law, civil procedure, arbitration, and intellectual property at Sri Lanka Law College. Mr. Jayasundara is also a well-published author and a regular contributor to local and international journals and other publications of law and legal studies. In introducing Mr. Avindu Rodrigo, President's Counsel, he is a counsel and head of the litigation division of FJ&G Deserum. He is a barrister of Gray's Inn, England and Wales, and an advocate of the Supreme Court of Sri Lanka. He counts over 20 years of experience advising and representing clients in commercial and corporate dispute resolution. His experience also includes acting and advising in matters relating to insurance, banking, and finance disputes, company liquidations, reductions of capital, mergers and acquisitions, minority protection and derivative actions, intellectual property disputes, product liability litigation, and regulatory investigations. He has extensive experience in arbitration and is currently advising and representing local and international clients in pre-arbitral negotiations, disputed adjudication board hearings, and arbitrations, including arbitral hearings held under the auspices of the Singapore International Arbitration Center, the International Court of Arbitration of the International Chamber of Commerce, and other ad hoc tribunals. He is also consistently ranked as a leading lawyer in Sri Lanka for dispute resolution by Chambers and Partners and Chambers Asia Pacific, listed in Band 1, leading individual for dispute resolution in the 2019 edition of Chambers Asia Pacific, highly recommended as a leading lawyer in dispute resolution in Chambers Asia Pacific, the client's guide, and endorsed as a leading lawyer in dispute resolution in 2013 by Asia Law Leading Lawyers. Mr. Rodrigo has co-authored the chapter on Sri Lanka in the Asia Arbitration Handbook, edited by Michael J. Moser and John Chung, first published in 2011 by the Oxford University Press. He has also assisted in the setting up of the Institute for the Development of Commercial Law and Practice, Arbitration Center of Sri Lanka. Thank you very much, sirs, for taking the time to be with us online today and discuss this topic. I will not ask both of you as to how your evening was, because I know that just 2 hours ago you were judging the final moot round of the Victor's Moot. So I will proceed straightforward to the discussion. And my first question to both of you is this. Since we have a lot of students in the audience today, and given that they will one day become arbitration practitioners and these are aspiring law students, and I think it's fitting to start with this question. So the question is, How did you find yourself in the arbitration practice? And what advice can you give to students who aspire to learn more and get involved in the arbitration practice? Mr. Jasundara, President's Council, if you may first answer this question. And
Thank you, Damitu. And good evening, everybody. Uh, we are going through a bit of a storm here, but it's okay. So how did I get into arbitration? Well, both Mr. Rodrigo and I had the fortune of working in the chambers of Mr. Kanagishwaran, and also had the fortune of working in that chamber when the Arbitration Act was introduced in 1995. Before that, did I know anything about arbitration? Absolutely nothing. Actually, the first encounter with arbitration that I had was Mr. Kanagishwaran inviting us for a workshop uh, at a five-star resort uh, down south when they were trying to promote the Arbitration Act. And both Avindra, myself, and lots of us, we all went. I didn't know what arbitration was. It was basically a free weekend in a five-star hotel. And we had a, if most of you might not know, in the introduction of the 1995 Arbitration Act, it was a collaboration between the Sri Lankan government and the Stockholm Chamber of Commerce and the Stockholm Arbitration Center. So there was this team of Swedish lawyers who came to train us and at least to give us an idea of what arbitration was. And it was a hectic 2 days over a weekend. There was not much fun that we thought we were going to get because the Swedish the trainers were hard taskmasters. So that was the first experience that I had, and they had maybe something like a moot, but a moot where Justice Tilakaratne, who was today a judge, was acted as the arbitrator, whereas Mr. Kanagishwaran was a counsel. The late Justice Prasanna Jayawardena was a witness, in fact, a drunk witness. Mr. Kalingin Fissa was a witness. Mr. Kushandi Alvis was a witness. It was all in our infancy in the profession. So we did have a lot of fun at that time. And even after that workshop, although we did have some idea of what arbitration was, the effect of arbitration actually kicked in when the act became operational, and specifically section 5 of the act became operational via arbitration, where there is an arbitration clause or arbitration agreement. One part of the arbitration agreement can't, if one party goes to court, the other party can object, and then the court is devoid of jurisdiction. So suddenly arbitration picked up in Sri Lanka because almost all construction contracts had an arbitration clause. An unforeseen circumstance, which we will discuss subsequently, was that even the lease agreements had, and financial leasing agreements also had, hire purchase agreements had arbitration clauses. So that became a problem later on. But I did my first arbitration in 1996, and that was before this whole leasing problem was there. And we finished that arbitration in about 6 months, a construction arbitration. Thereafter, of course, working with Mr. Kanagishwaran and then subsequently on my own, we got into arbitration as a area of law to expand our practice. And also, I think, again, because of Mr. Kanagishwaran's influence, we got into international commercial arbitration also. Both Avindra and I, in fact, we have been opposed to each other in an international arbitration in Singapore. So then it just kept on developing. There are problems which we will discuss under when we discuss other issues about the Arbitration Act. But that's how we all got into it. We had the fortune of being there when arbitration came back and became a law in Sri Lanka in 1995. Thanks, Dan.
thank you very much, sir. President's Council, Mr. Rodrigo, we would also like to know your history and how you got into this practice.
Yes. Am I muted? I'm okay. Yeah.
No, sir, we can hear
Yes,
you.
so it was, as Mr. Jasindra said, it was something completely new for us, and we had not experienced what an arbitration was. Um, and we were lucky to be involved at the point at which the act came into force, the drafting of it, when it was introduced and introduced to the lawyers. There was some degree of reluctance on the part of the profession to accept arbitration as it was, particularly in view of Section 5, which was a first in for most countries. That is where you have exclusive jurisdiction, or where there's an arbitration clause, the other party can object to court exercising jurisdiction. This was new. It had not even been introduced in Sweden at the time, with the Swedish lawyers who were involved in it through Swedfund and other institutions, that we introduced this. So this was new law. And then, as for me, when I first got into arbitrations, a couple of them, I think both of them, the bigger ones at least, were international arbitrations. So I have to say I was fortunate in that. And it was quite strange to have um, I remember the Oberoi arbitration was one of the first. I can talk about it because it's reported in the Supreme Court decisions, and where you had three Englishmen who descended on Sri Lanka and here we were a bunch of Sri Lanka lawyers who had to make submissions and appear and be able to talk to and gain empathy of a completely new and almost alien set of adjudicators. And in that, as well as, say, the intercontinental arbitration, which took place around the same time, the experience that I had, which was positive, was that you are dealing with specialists. That's what actually initially attracted me to arbitration. Most often, the arbitrators will be picked for their speciality. So, like Mr. Jacinta was saying about construction arbitrations, you would have construction specialists. They know the technical subject, and that makes things a lot easier and faster. Also, the fact that you get into the substance of an issue without getting involved in procedural pitfalls and debacles, if you like, on the way, delays that happen on the way, and that you are able to get in fairly quickly into the merits of a dispute. And that is what has primacy in the whole proceeding, not questions of interpreting the civil procedure code and things like minor evidentiary issues that crop up. So that is, for me, what attracted me to arbitration in the first place. And also, I have to say, because of the fact that you're focusing on the merits and also, as a corollary of that, the law, the standards in some arbitrations, I can't say all, are very high. And that is something that I find attractive even to date, because it brings out the best in you, because you are talking to and dealing with a forum, a tribunal, which is one specialized as well as of very high quality, because you're paying usually high prices for them. So that is what attracted me to arbitration. Yes.
If I may add a follow-up question to what you just told us now, sir, between then and now, then being when you and Mr. Jayasundara started your practice, and now, do you think the challenges to budding lawyers in getting into this field are more or less? And if so, if it's a yes, what advantages do budding lawyers now have to that was before.
Yes, so Chandaka, I'll start on that.
Yeah.
So the first part of it is this, that when we began, I have to say, sadly, arbitrations were not being conducted the way arbitrations ought to be conducted, in the sense that they were also getting bogged down in procedural quagmires, and the quality of the arbitrators were also not not as good as some of the arbitrators available now. And also, arbitrators were not familiar with the fact that it should be different to a court proceeding. It should not be, as we used to talk about, court sitting in the evening. So that difference is there now, in that people are more accepting of arbitration to begin with. The obstacle of people not accepting it is almost gone. The arbitrators that are available now are cognizant of the differences in a court case and an arbitration. And also, because of that, and otherwise, there is quality arbitrators available. So for someone to get in, it is easier now because you don't have to go through all of those other problems that were there at the time that Mr. Jasindra and I began doing arbitrations. Yes, that's my answer.
Thank you, sir. Mr. Jasundar, do you have anything to add to
Yeah,
that?
I think Mr. Rodrigo has touched on most of it. I think one of the biggest problems was there that it was a very nascent area of law. We didn't know what we were doing. The arbitrators didn't. They knew. And one of the factors was that as at that time, the nominated arbitrators were mostly former judges, retired Supreme Court judges, retired judges. So there was this natural inclination of replacing the arbitral process with the judicial system with regard to evidence, with regard to issues. So it became a bit of a problem. But now, because some of the most virulent dissenters of arbitration are also now some of the best arbitrators and arbitration lawyers also now. I'm not talking about the small leasing arbitrations and consumer arbitration. I'm talking about the more high-end construction investment arbitrations. Now the lawyers and the arbitrators are of much higher quality. We are not praising our own selves, but maybe the lawyers have always been quite up to it, but the quality of the arbitrators with all this training and everything has gone up. So and there is a lot of opportunities now because we had no Victor's Moot, nothing to learn what this arbitration was. We had no diplomas, we had no LLMs, nothing on arbitration in Sri Lanka. So it was all a learning experience for us. But now most of that is available in Sri Lanka, and the quality of arbitrations have also, I think, improved. At least the major arbitrations. So it is a field that you can always. I don't think you can do exclusively arbitrations at the moment because we are very tight market. It's very difficult to focus yourself on one particular aspect, but it's definitely not only arbitration, but we'll discuss later alternate dispute resolution as a method of dispute resolution. Alternate method of dispute resolution is a vast area where opportunities are coming up. You don't have to get stuck in court. So it is an area that is quite attractive for a young student to look at.
Just to add one thing there, something very welcome today is that you have counsel and good counsel at that, like Mr. Jasundara, who sit as arbitrators. You see, this is something that we didn't have at the start. And also, I think the younger lawyers are now getting several qualifications in arbitration, which again were not available at that time. So these are welcome changes. and developments that would make it easier for younger lawyers to get in. Yeah.
Thank you very much, sirs, for your input on that question. I would like to move on to the next question on this discussion, and this question is for Mr. Rodrigo. The question is, in drafting an arbitration clause, an arbitration agreement, the decisive factor there is the selection of the seat. And what do lawyers and parties typically look for when drafting an arbitration agreement and selecting a seat? And if you may refer to Sri Lanka as being a potential seat, and what would help Sri Lanka be chosen as a seat for arbitrations in when parties draft their arbitration agreements, uh, that be helpful, sir.
All right. So the first thing I think everyone should realize is that there is a difference between what is called the venue and the seat. So the seat of arbitration is what is important. That is where the arbitration as a matter of law is situated. And why the seat is important is two things. One is that the procedural law that will govern that arbitration is going to depend on the seat of arbitration. Okay, if you're with me up to that point. And then additionally, the supervisory jurisdiction that a court has would depend on where the seat is. So if you have an arbitration where the seat is Sri Lanka, you can have the supervisory jurisdiction would be that of the Sri Lanka courts. That is the commercial high court, as you know, will have that supervisory jurisdiction. And then as far as the law that would apply, that law would, I'm talking about the procedural laws, that would be our Arbitration Act of 1995. So that depends on the seat. So choosing a seat can be quite a strategic exercise at the point at which you put in the arbitration clause in the agreement. So if you fear, for instance, that arbitration that is seated in Sri Lanka, even though the tribunal might be independent, that is, even if the arbitrators are foreign, say, and independent because they are foreign, or independent because of other reasons but are local, if the courts are going to have some kind of supervisory jurisdiction on it, though it's limited, it still does exist, then a party who's foreign, say British or English company, would not want necessarily for a Sri Lanka court to have supervisory jurisdiction over a dispute that they are going to put into arbitration. Okay, if you follow what I'm saying. So because of that, parties will think about the best place to put in as the seat of arbitration. And oftentimes, when there are parties, say for instance in Sri Lanka, and you have another party in Europe, they will pick a neutral venue which has also several things. For instance, it should have a good infrastructural law for the conduct of arbitration. So as you know, Singapore is one of the preferred destinations for arbitration for international disputes in this region, actually, for the reason that they have they have the statutes that play a strong supportive role, which are pro-arbitration rather than being anti-arbitration. So that is a factor. And of course, things like the infrastructure that they have in terms of facilities for an arbitration to be conducted successfully and easily in Singapore is a plus for that. You have also Malaysia and Hong Kong, both of which have quite developed centers and developed laws in respect of supporting arbitration. So it is something that quite a lot of thought should be given to. It should not just be picked out of a hat, so to speak. And we have to also understand that just because the seat is in Singapore doesn't mean that all of us have to travel to Singapore. And of course, some of us might like that with the Chinese food and everything that we can eat there, but perhaps not at this time. But you can still have the arbitrators that come here to Sri Lanka. So the venue can be here, if you're following me. You can have the physical hearing in Sri Lanka, but the seat can remain in Singapore. Okay, so that is the point in it, that it need not be synonymous, that the seat doesn't mean that you have to go to Singapore or Malaysia or Hong Kong. So it has to be picked carefully given those factors. Particularly if you fear that the other side is going to throw procedural obstacles in the way of a successful arbitration, then I have to say it might be useful to move the seat to a neutral country out of Sri Lanka. And then those courts are loath to accept procedural objections. Mr. Jasundra and I actually observed a high court in Singapore dealing with an objection of that sort. And so it is something that has to be chosen carefully. And I would say the safest course would be to pick a seat that is out of Sri Lanka. It is going to be a highly contentious, large arbitration. Having said that, we have to also understand that for us to practice, it is better if the seat is here, because we are the only lawyers who have rights of audience before an arbitration arbitral tribunal that is seated in Sri Lanka. Okay, though we can go and appear in Singapore also, even if the seat is there, but in Sri Lanka, you cannot have foreign lawyers appearing in an arbitration that is seated here. Okay, does that answer your question or anything further on that?
Yes, sir. If I may add to that, sir, given that the parties opt for arbitration to opt out of courts exercising jurisdiction over the potential disputes they might come across, and given that even if you come to arbitration, that the courts will be exercising supervisory jurisdiction over the adjudication process, do you think when selecting a seat for the arbitration, for the purposes of the arbitration clause, parties also look at whether that country's judiciary is known as a pro-arbitration judiciary, or whether court intervention is minimal or whether it is not so minimal? What are your thoughts on that, sir?
Yes, certainly they do. That is something that is vital. It's not only the attitude of the judiciary, but also the statutes that they have that support or not support it, but certainly the attitude of the judiciary also. So there is, in most of these countries, a general policy of usually encouraging foreigners to come to their country and adjudicate their disputes there for obvious financial benefits that the venue gets. So if we have an arbitration in Singapore, we'll all have to travel there. We'll have to spend money on facilities there. We will have to stay there and all of that. So it's something that a place like Singapore, Hong Kong, and even Malaysia encourages. So the general judicial attitude to arbitrations in those countries are positive, and they also cherish the concept of not interfering in the process unless there has been obviously some blatant material irregularity which they have to come and correct. So yes, the judicial attitude is important. I can't say what foreigners presently view our judicial attitude as being, but I can say that as far as those other countries that I mentioned, yes, they seem to have a positive attitude, and I have no concern in having arbitration that, say, a Sri Lanka client and a foreign client have being adjudicated in Singapore. Something happened. Because of the reason that I would be comfortable that the judiciary there is not going to interfere and will allow the process to continue without problem.
It is not that the Sri Lankan policy with regard to being pro-arbitration is lacking. I think the government, not the government, right? We all make the mistake of calling it a government, but the state does encourage arbitration, and to the extent that in the port city they are trying to make it mandatory. It is also true of Sri Lankan judges that they are pro-arbitration, and there are judgments of the Supreme Court where Justice Salim Masuf and Justice Shirani Tilakawardena have specifically held that the court's intervention should be as minimal as possible. The judges who sit in the arbitration court also have no problem, and the attitude has always been with the different judges who come there is non-intervention as much as possible, and to have a role of supportive. But the problem, as usual in Sri Lanka, is that even to get a procedural order from court to appoint an arbitrator, to any of these, even the procedural about jurisdiction, say appointment procedure which should take only one sitting will take at least 6 to 8 to 9 months. The enforcement procedure is unbelievable in Sri Lanka, because, as you know, in more arbitration-friendly countries, enforcement doesn't take more than a year from the conclusion of the arbitration, if not maybe a maximum 2 years. Now, the arbitration, I mentioned that I was in one of the first arbitrations under the Arbitration Act. We concluded the arbitration in 6 months, so I think it was like end of 1995 or maybe beginning of 96. The enforcement procedure, ultimately it was settled, but it was settled because the clients, both clients, got sick of the fact that a 1996 arbitral award was still being enforced, and the case was still pending in 2014. So it's unbelievable the amount of time that our judicial system takes over cases. That is an inherent problem in the judicial system. So we'll have to, but as long as that problem is there, as long as our judicial, not the judicial system, the justice system doesn't provide that sort of confidence that Mr. Rodrigo was saying, as they give in Singapore and Malaysia and Hong Kong and even in England and Australia, that kind of, unless and until our justice system gives that confidence to investors and parties who seek to have arbitration, arbitration is not going to take off. International arbitrations are not going to take off. The sad fact is we are sitting in at the doorstep of one of the biggest legal markets in the world, in India. Not one arbitration from India comes. They don't even consider Sri Lanka. They might consider Sri Lanka as a venue because of the infrastructure and everything, which I suppose is better than India. But they will definitely not consider our justice system as supportive. So all that work is going to Singapore or Dubai or KL. So those are that is the pitfall that we are facing. If not for the problems which the Justice Ministry is trying very hard to overcome, if not for that problem, and until and unless that problem is solved, international arbitrations in Sri Lanka will not take off.
Thank you very much for your input on these questions, sirs. I would like to move on to the next question. And this question is, this can be answered by both of you, but if I can start with Mr. Jayasundara. How is the ADR climate in Sri Lanka, and are there other aspects of ADR such as mediation and adjudication that are improving in Sri Lanka? If they are not improving, how can they be improved, sir? Now, this is in the context of the Moot problem also being a construction, based on a construction dispute. we have seen that a lot of contracts that are used in construction disputes are standard form contracts, and they contain tiered arbitration clauses where there are pre-arbitral steps parties need to follow, like referring their dispute firstly to DAB, a dispute adjudication board, and then taking time to amicably settle their disputes, and then referring their disputes finally to be resolved by arbitration. So in that context, what are your thoughts on the ADR climate in Sri Lanka, sir?
Yeah, so as we all know, ADR, alternate dispute resolution, is not only arbitration. There is one preceding that, negotiation, mediation, and also adjudication. As you very correctly said, most of the standard form contracts, especially in construction contracts, the ICTAD standard form has a process of adjudication where an adjudicator is appointed to decide matters as the contract goes on. So now, most of the disputes that have arisen in respect of the Southern Highway construction, the Central Highway construction, that is technical disputes that come up all the time, are being settled by adjudicators who are sitting in sitting on almost on a daily basis sorting out. It is only if the adjudication, it is only like those sort of disputes now coming to our sphere only upon the conclusion of agreement or breach of agreement, and when the matter becomes a bit too hard for the adjudicators, or the adjudicator's decision is not or one party is not happy with the adjudication. So adjudication itself is a very important aspect, but most of the time adjudication is at least in Sri Lanka is being used mostly in construction contracts. So you will, an adjudicator, if you want to be an adjudicator, you will need to have some sort of expertise in your subject area, because adjudication is generally not done strictly in terms of the law, but in an effort to quickly resolve the dispute for the contract to go on. Negotiation is, of course, as we know, the word itself says it's negotiate, whether you can negotiate and solve it. There is where negotiation in Sri Lanka is generally private, done between the disputant parties. One of the most important aspects and one of the most aspects of ADR that is coming up now is mediation, because commercial mediation is becoming quite relevant in commercial disputes in in the world, and especially in the world, because arbitration was an alternative to litigation, because litigation was time consuming and costly. Now arbitration is also becoming a bit time consuming and costly. So now everybody is trying to see whether mediation is a possible manner, a possible way of, or better way of alternate dispute resolution than arbitration. So I think there are serious discussions going on to amend and even to bring in a new act on commercial mediation in Sri Lanka. There is a Commercial Mediation Act, I think from 1980 or onwards, or 88 or something, I'm not sure the year, but which has never been used. It was a mediation, we call it center-centric mediation. So they set up a mediation center with the Colombo Chamber of Commerce, but it never took off as such. But now there is a renewed interest in mediation, and there's a lot of training going on in mediation. There is, at the moment, I think for the first time, mediation center has been introduced by the ICLP, that is the Institute of Commercial Law and Practice, together with the Colombo Chamber of Commerce, Ceylon Chamber of Commerce, which has now set up a ADR center, which will deal with arbitrations and mediation. So, so there is scope for, of course, when you speak of mediation, there is a lot of scope for mediators. If you're good at mediating problems at law college or wherever between your friends, that is definitely something, because your mindset has to be quite different. Mediation is also for lawyers in advising and in appearing in mediation. There's a lot of scope, because that is going to be, mediation definitely is going to be the next stage. So this is the first center that ICLP and the Ceylon Chamber of Commerce has started. Like that, more centers will come promoting mediation, and I think there's quite a big push from the government and international agencies to see whether we can move on to mediation also as an alternate dispute resolution. Now, what is important there is, for mediation, unlike in arbitration, there is no involvement in by the court system. So the end result of a mediation, the settlement, will be a new contract giving rise to new problems if there are problems, but the actual mediation process exists without the judicial system. So one of the biggest problems in the arbitration sphere of the problems that I mentioned about the justice system is not there when it comes to mediation. It's a wholly and completely private matter that can be easily done in Sri Lanka, because one drawback at the moment is that we don't have many trained mediators. It's a very high paying job, like for major mediations between oil companies, environmental mediation, labor mediation, it pays a lot. So until then we can bring outside mediators, foreign mediators, but that also will develop. So one of the major, because as far as I am only talking about South Asia, that is India, Pakistan, Bangladesh, Nepal, they all have to go to Singapore for all these things at the moment, because we are the only people who they find us attractive as a tourist destination. They find us attractive as a shopping destination. Same attraction we have towards Singapore. So if the South Asian countries and the business people like coming to Sri Lanka anyway, why not provide them the infrastructure and the basic laws to enable? So because I always say we are sitting on a minefield, on the biggest legal market in the world, 22 miles away. Thank you, Damita.
Thank you, sir. Mr. Rodrigo, sir, do you have anything to add to that?
Yes, I think a couple of things. As Mr. Jasundra said, we should not think of ADR as something additional, but it should be something that is part of our infrastructure. Because if you look at it, in as much as you must have a court system to adjudicate disputes between parties, in the same way, when you have commercial disputes that arise, it is a must, even as far as Sri Lanka and internal, where there is disputes within Sri Lanka, between Sri Lanka companies, that we have this availability of mediation, availability of arbitration, and high quality center that is both in terms of the rooms and the facilities in those rooms. And as you know, we have, and thankfully that continues to be the case at the World Trade Center, first class set of rooms where you can conduct any level of arbitration. Now, on top of that, as Mr. Jasundra touched on, we now have a comprehensive set of rules which is coming out of the CCC, that is the Ceylon Chamber of Commerce, and the ICLP, both in respect of arbitration and alternate dispute resolution. So we have that in place. We have, as I said, the center in place. We also have quite a progressive act in place, which can facilitate or allow for arbitrations even between non-nationals to occur within Sri Lanka at our centers. So we are really open for business right now. We have all of those things in place, but it's just a case of attracting some. I honestly do not know of a single instance of two foreign entities who have no connection in Sri Lanka deciding to have an arbitration seat in Sri Lanka. I don't know if Mr. Jasundara has an instance, but I certainly have never experienced that. All we have is where one party or the other or the subject matter is located in Sri Lanka. If not, people don't come here. Now, one other thing that I thought perhaps we can touch on at this point is virtual hearings. So, increasingly, and this is something productive that has come out of the pandemic, is that today, increasingly, we can have virtual arbitral hearings. As you know, we are already having those, some of them at least even in our courts, but in an arbitration, also it is very possible, and in fact it can be a lot easier because the arbitrator is the master of his own procedure. And right now there are several sets of rules or guides, shall I say, which provide for virtual hearings. So let me describe what a virtual hearing is first. That is where the seat may be, as I said, Malaysia, for instance, in Kuala Lumpur, but you could have the arbitrator joining virtually the party and the counsel in another country. Recently, we had an arbitration where there were witnesses in Europe, there were witnesses in Australia, there was two of the arbitrators were seated in Singapore, one arbitrator was in Colombo, us, the counsel, were in Colombo, and the transcribers, those are the people who take down proceedings, were in London. And with all of that, I have to say we managed to conduct a very successful arbitration. It went off as well as any physical hearing. Yeah, it was a lot less pressure and time consuming on the arbitrator, less time was consumed of the arbitrators because they didn't have to travel here, they didn't have to stay overnight, they didn't have to get accommodation, any of that. So virtual hearings are changing the whole face of arbitration. And I can tell you that already there is CIAB guidelines on remote dispute resolution proceedings. ICC has a guidance note. The Seoul Protocol on video conferencing in international arbitration is there, and the Hong Kong Arbitration Center also has that. So this is going to be the way arbitrations are going to be conducted more and more in the pandemic and beyond that, because certainly arbitrators are slow to travel. They don't like to go here and there often. So it will be much easier for them just to join by video conference. Yeah.
Thank you very much, sir, for your input on that. We are mindful of the time constraints in this panel discussion, as there is a further agenda scheduled for today's proceedings. We have come to the end of our discussion and we are open to questions now. We have already received some questions, and the first question is for Mr. Jayasundara. So the question is there any specific qualification that need to be obtained in order to be eligible to practice both as a counsel and particularly as an arbitrator?
To work as a counsel, or if you are dispensing legal advice and you are representing a client as a lawyer, then there are strictures that have been put up by the Supreme Court that there is act interfering with pleaders, intermeddling with pleaders ordinance, which says that only lawyers qualified and licensed by the Supreme Court can practice law. That is why Mr. Rodrigo mentioned that even if you have a arbitration here, internationally or foreign lawyers can't come and represent, because it is specifically provided that only people licensed by the Supreme Court, as we are attorneys at law, can practice. So if you're dispensing work as a lawyer, giving legal advice and appearing in arbitrations as a legal as a lawyer, then unless you are recognized by the Supreme Court of Sri Lanka, you can't. However, the Arbitration Act does permit representation by non-lawyers. That is no problem. There are instances, especially very specialized contracts, where engineers represent the clients. I have done arbitration where I looked after the legal part, and the technical part was looked after by a chartered engineer, because it was the issue was too complex, even too complex for a lawyer to handle. So that is available. But if you are doing legal advice and legal representation, then you have to be certified as a lawyer by the Supreme Court. To be an arbitrator, no, you don't have to be. Some arbitration agreements specify the qualifications of arbitrator. It might be a law. They might say lawyer. Some say retired Supreme Court judges. Some say it has to be somebody from the industry who has experience in the industry. So the qualification, if at all, to being an arbitrator is restricted. One, by if there is any qualifications required in the arbitration agreement itself. Otherwise, if the client wants to appoint anybody, of course, subject to impartiality and all those other criteria, you don't have to. You don't need much qualifications. But now there are qualifications available. Even from here, you can get the membership at the Chartered Institute of Arbitrators in England. Also, you can get membership from the Singapore Institute of Arbitrators, which will add to your portfolio. Other than that, there is no requirement, legal requirement.
If I can just add there that Mr. Jasundar talked about this, about our market being such that it will be difficult for you only to specialize in arbitrations. And certainly there, we have to also appreciate that when we are talking about large international arbitrations, that the approach not only of the tribunal but of the council also is different. You don't have the same level of, shall I say, animation that you have in a court. So the cross-examination, for instance, would be quite mild compared to the type of cross-examination that we are used to in the courts. The type of the attitude that the witnesses have, as well as the counsel has towards the witnesses, is different. So this is something that one has to understand. There are differences there. Then on top of that, if you tend to only be doing arbitrations, and that I have seen, witnessed not in our local lawyers so much, but in foreign lawyers, they tend to lose their teeth a little bit, in the sense that they become a little too mild to come back and practice in court again. So a mix of the two, I think, is what should be followed at a young age and thereafter even.
Thank you very much, gentlemen, for taking the time to enlighten us on this very timely topic. Unfortunately, we are unable to take any more questions due to the time constraints. So from here, let me thank both of you for taking time off to come and speak on this topic. And we are aware that you have been with the Victor's Moot, with the Moot Society of Sri Lanka College right throughout from the beginning itself. And both of you have always been very inspirational to us, and you have helped us in bringing the Victor's Moot so far from its inception. Many of the participants at today's panel discussion have also tuned into various other panel discussions where both of you were panelists, and I'm sure this panel discussion too wouldn't be any different to those, and that all of us had something to take home today as the outcome of this panel discussion. So thank you very much, sirs. I will hand over the floor to Sairu again.
Can I just, on behalf of myself and Mr. Asundra, thank everybody for all that you have done. I have to say that I can't remember what the year was when the Victor's Moot was first mooted, shall I say, and you were going to have a international moot like this in Sri Lanka. I wondered whether it was going to be successful, because this was when the first one was being talked about. I remember meeting the students, but it appears that you have done well and it's been successful. So congratulations on that.
Thank you very much, sir.
Our heartfelt gratitude goes out to Mr. Avindra Rodrigo, President's Council, Mr. Chandaka Jayasundar, President's Council, for imparting their views, knowledge, and experience with fellow attorneys, the attorneys of the future, and also for everyone who joined this panel discussion. And we would also like to thank Mr. Damitu Surasena, Attorney at Law, for his skillful moderation of a very efficient and productive panel discussion. Gentlemen, thank you very much indeed.